do these on a regular basis, as you probably know, and I've got a number of topics to talk about tonight. The first one is the liquidation application by KWGS with respect to GHCC 2016 Limited. As you may recall, that application started last year and it was adjourned on the basis that Oliver's barrister promised that a new creditor's proposal would be put forward by the 20th of December last year. Now, as usual, that did not happen. It came as no great surprise. So that's another promise that's been broken. So now we got to the stage in 5th of February when the matter was called again by the court. And the court, despite further objections by Oliver's barrister, put the company into liquidation. Now, what does that mean? It means that a liquidator has now been appointed. That liquidator is a company called Waterstones, and that team of professionals is very, very experienced and has had experience in a previous case where they were liquidating one of Oliver's companies. So they're well experienced with all the promises that are made and never acted upon. So what's the next steps? The next step is to obtain copies of all bank statements or contracts or accounts and effectively follow the money trail to see if there is any money left in the company or that can be clawed back in some way. Now, this means, of course, that if we find that the company was trading while insolvent, then there is personal liability with respect to the sole director, who is a fellow called Wayne Bailey. And in addition to that, we also have 2 disputes tribunal decisions where the disputes tribunal found that Bailey was personally liable. So we intend to pursue that action against him personally and possibly against Oliver as well, on the basis that behind the scenes he was acting in all probability as if he were a director. So we'll get copies of the bank accounts, the bank statements and the annual accounts of the company. It may be that we have some difficulty getting that, but the liquidator has powers that we don't have, and we'll be exercising those powers. So that's the status of the liquidation proceedings, and we will keep you informed of what's happening, but it is certainly a step in the right direction in unravelling the structure that has been put in place by Oliver. The next point I want to talk about is a personal bankruptcy application which has been made by the BNZ Bank against Oliver. Now, that is unrelated to the golf course. So it relates to what we believe to be a personal guarantee that Oliver gave to the bank with respect to another property transaction which failed. The barrister acting for Oliver promised that a creditor proposal would be put forward by the 31st of January this year. To the best of our knowledge, that has not occurred. It is possible that something has occurred, but we're not aware of anything. Now, what that means is that if a creditor proposal is not accepted by the creditors, then on the 24th of February, the matter will be before the court again, and assuming that no proposal has been accepted, then Oliver will be declared bankrupt on that date. Now, of course, there are all sorts of tricks and promises that may be made to try and extend that, but that is the situation as we understand it at the moment. Once somebody has been declared bankrupt, their assets become under the control and effectively owned by the official assignee. Now, that means that the official assignee will, for example, control the shares in Phoenix, which is the holding company for the golf course land. Phoenix owns 100% of Long River, and Long River is the golf course owner. The 100% shareholder of Phoenix is Oliver. So what that means is that the shares in that company which controls the golf course and indeed owns effectively the golf course would pass to the official assignee. So that means that the official assignee has the ability to sell those shares. So to all intents and purposes, when that happens, Olliver is out of it one way or the other. The first mortgagee, which is the American Private Equity 1543 Capital Limited Partnership, they have the right to exercise either a receivership or, if there is a clause in their mortgage which we call mortgagee in possession, they have the right to sell that property or deal with that property in some way. Now that is an advantage to us, because with Olliver out of the way, all these false promises that have been made and not kept over the years are just not on the table anymore, and we would be dealing with somebody who is a reputable organisation in the States and has the financial capability to make something happen. Now we understand that their preferred position would be to sell the golf course, but that's only one option. They may decide that they want to stay in. They may lease it to another party, we just don't know, but their preferred position, as we understand it, is to sell the golf course. Right, the third point that I'd like to make is that KWGS is now looking to commence a class action against Long River for diminution of property values. Now this comes about because the 999-year encumbrance requires that the golf course land be operated exclusively as a golf course and country club. And by shutting the golf course, closing it and effectively letting it go to rack and ruin, then they are in breach of that encumbrance. Now, people who bought properties in the Gulf Harbour area mostly relied on that encumbrance to ensure that the golf course continued, the open spaces were available, and that now has not happened. As a result of that, property values have decreased. That's decrease over and above the general decrease in the market. That could amount to something in the vicinity of $200 million. So we're proceeding with a class action. It's a question of watch this space. In due course, we will offer the opportunity for landholders, property owners, to participate in that class action. Now, I don't want to raise any expectations that all of a sudden you're going to get money from Long River. It's more a tactic to ensure that our position is protected as it possibly can be in terms of continuing to see a golf course and country club operating on that land. And the class action will facilitate that process. So we'll keep you informed about that, but that's the next legal action that we're intending to pursue. Now, the important thing to remember is that an encumbrance runs with the land. Now, what that means is that any person who subsequently purchases the land or takes control of the land from 1543 is also bound by the terms of the encumbrance. And it's not possible to simply say, well, I'm a new owner, therefore I'm not bound by that. It's called running with the land. The encumbrance is secured on the land title. And so to all intents and purposes, whatever obligation Long River has as encumbrancy, so does any subsequent purchaser of that property. And so it will be incumbent on us to make sure that any prospective purchaser is aware of the encumbrance, and secondly that they're aware that a class action is in the winds. Now, of course, if we got a guaranteed response from a purchaser that they will operate it again and put it back into place as an 18-hole upmarket golf course, then that class action would be removed. But that would be an assurance that we would need to have with absolute certainty. We have also produced an invoice which has been passed on to Long River for the various works that your community trust has undertaken to keep the golf course clear. That invoice amounts initially to something in the vicinity of just under $30,000, and so that claim has already been sent to Long River. What that means is that potentially we become a creditor of Long River, and that gives us status before any bankruptcy or liquidation proceedings that relate to Long River or Olliver personally. So again, we've got a number of things running, and consequently you can be certain that your committee is following up every opportunity to make sure that the golf course is placed back in full operation again, and everybody can happily ride off into the sunset. Now that's not going to happen in the next few months. I mean, we may be several years away from that. But I think there is a momentum building at the moment. There are a number of options that we've been exploring, which at this stage I can't disclose, but they are happening. And so I think if you watch this space, we will update you on a regular basis as to the legal status of the various things that are going on. So thanks for your time, and I look forward to being able to talk to you at a later date.